Right. The Jomo Kenyatta International Airport case has been in the public realm for quite some time. The government of Kenya, through a unconstitutional act, the Public-Private Procurement Act, went unilaterally to identify an investor, put the airport in the hands of that investor in secret. A 30-year deal amounting to 268 billion shillings was being negotiated and to be finalized between the government of Kenya, the Kenya Airports Authority, and Adani's company, the Adani Group. At the beginning of this process, we raised concerns about the propriety of the adventure because in Kenya there are two ways to procure public services, and they are all enumerated in the Public Procurement Act, which is by public tender or an expression of interest, where competing parties are able to put forward their bids, which are evaluated, and of course the competition or the weight results are able to be assessed by the Kenyan people in order that the winner is a deserving winner. When we challenged the way in which the Adani Group was being given the airport, the government muscled through by first of all forcing the workers to call a nationwide strike, and under threat and under protest, the workers were shut quiet or shut down. I instituted a petition in the High Court, Tony Gashoka versus Adani. I incorporated various groups of public interest, the Wiper Democratic Party, the Jubilee Party, and the Democratic Action Party, because it was critical for me for this to become a public interest matter, not an individual matter. While we were prosecuting this matter, we had three issues of objection. We objected to the fact that there was no public participation at all involved in even the award or discussion toward raising money to invest in the Jomo Kenyatta International Airport. Secondly, there was want of public satisfaction because of lack of parliamentary approval. Parliament was kept in the dark about the transaction. And the third issue is that there was nobody competing against Adani. It was a deal signed in silence and pursued in silence. So we went to the High Court. While in the High Court, the East Side Court of the District Court of New York went ahead and indicted Adani on fundamental issues of lawlessness and criminal activity. What worried me the most was the criminal fraud. Adani was charged and indicted in the US for bribing in the amount of 265 million, equivalent to 34 billion, the government officials of India, in order to acquire a solar plant, exclusive solar plant worth 2 billion shillings. If you do a calculation of 265 million against a 2 billion award tender, Adani paid 10% of the award to the officials in terms of bribes. In Kenya, the Jomo Kenyatta transaction over 30 years was 268 billion. So 10% of that amount would be 2.6 billion. We are saying that the Adani Group paid Kenyan officials, government officials, in excess of 2.6 billion shillings to sign the deal of the Jomo Kenyatta in the same way they did in the indicted proceedings in the USA.